Good morning, this is lawyer Fabio Loscerbo, and you are listening to a new episode of the Immigration Law Podcast. Today we examine an important decision published on the 21st of November 2025 by the Regional Administrative Court of Sicily, 3rd Section. The case, registered under General Docket number 851 of 2025, concerns the refusal by the Police Headquarters of Palermo to convert a special protection residence permit into a residence permit for subordinate employment. The case mirrors a situation that many foreign nationals are facing in recent months. The applicant had obtained special protection following a judicial decree issued on the 8th of May 2023 by the Court of Palermo, which recognized the relevance of his path of social and work integration. The court stated that removing him from Italian territory would unjustifiably interfere with his private and family life. Based on that judicial order, the police headquarters issued a 2-year residence permit. Later, in August 2024, the foreign national signed an open-ended employment contract as a domestic worker. In October of the same year, he applied to convert his special protection permit into a work permit. The police headquarters denied the request, arguing that the special protection had been granted within proceedings related to international protection rather than in connection with an application for special protection submitted before the 5th of May 2023, and therefore the transitional regime under Article 7 of Decree Law 20 of 2023 would not apply. It is precisely at this point that the judgment of the Sicily Regional Administrative Court provides a clarification of significant practical impact. The court states that the police headquarters applied an excessively restrictive interpretation of the transitional regime. The central point is this: the intertemporal rules introduced by Article 7 of Decree Law 20 of 2023 do not distinguish between the procedures through which special protection was granted. The only relevant requirement is that the applicant's request for special protection was submitted before the 5th of May 2023 and that the administration's subsequent refusal was declared unlawful by a judicial authority. The court expressly refers to the opinion of the State Legal Service, which states that conversion is permitted for all special protection permits recognized by a court, regardless of whether they originated under Article 19 of the Consolidated Immigration Act or Article 32, Paragraph 3 of Legislative Decree 25 of 2008. In other words, there cannot be two types of special protection, one convertible and one not, because the statutory requirements are identical. The judgment also recalls a key passage from recent administrative case law, which states that the law has established a single temporal threshold for the convertibility of the title, namely the date on which the special protection application was submitted, and no other conditions. In practical terms, the police headquarters cannot add restrictions that the legislator did not impose. This approach, consistent with rulings of the Council of State and other regional administrative courts, leads the Sicilian bench to annul the refusal and recognize the applicant's right to convert the permit, also confirming his admission to legal aid at public expense. From an operational standpoint, this decision has considerable weight. It consolidates a clear and now stable principle. Anyone who submitted their special protection request before the 5th of May 2023 and subsequently obtained judicial recognition of their right maintains the right to convert that permit into a work permit, provided that a valid employment relationship exists. This is not a mere technicality. It is a decision that protects real paths of integration and prevents administrative delays or lengthy court proceedings from unfairly penalizing the very person who acted in accordance with the legal framework in force at the time of the application. Once again, administrative jurisprudence steps in to restore coherence, ensuring that foreign nationals are not subjected to unjustified disparities in treatment. And this case confirms how essential it is for foreign citizens to carefully review administrative decisions, because restrictive readings can jeopardize rights that the legal system expressly recognizes. This concludes today's analysis. I am lawyer Fabio Loscerbo, and I thank you for listening to this new episode of the Immigration Law Podcast. I look forward to our next discussion of another significant decision in this evolving field.